Okay, continuing on from part 2. We talked about how a terrorism act is an act designed to cause injury to life or limb, take someone's life, cause them permanent harm, or to cause an act of infrastructure damage. Burn someone's house down could be considered to be a terrorist act. Continue down the list. As we can see from the previous episode, endangers a person's life other than the life of the person taking the action. So suicide comes under a different bracket of law. Creates a serious risk to the health or safety of the public or a section of the public, or seriously interferes with, seriously disrupts or destroys an electronic system, including but not limited to an information system or a telecommunications system or a financial system or a system used for the delivery of essential government services, or a system used for or by an essential public utility, or a system used for or by a transport system. This covers a lot more than just the government. And this would also cover government employees that would intend to cause information system damage or telecommunications systems damage. So it works both ways. An action falls within this subsection of it. A is an advocacy, protest, dissent, or industrial action, and B is not intended to cause serious harm, that is physical harm to a person, or to cause a person's death, or to endanger the life of a person other than the person taking the action, or to create serious risk to the health or safety of the public or section of the public. An action of the act of terrorism falls within this subsection if it is not intended to cause serious harm, that is physical harm to a person, or it doesn't make sense. It's out of context. You've just repeated yourself from section 2 and then flipped it on its head 180 for section 3, meaning that both sides of the scales are considered to be terrorists. How does that work? Is advocacy, protest, dissent, or industrial action, and it tends to cover protests. This is where they've turned your protests against what their actions are into terrorism against the state. So this is the state writing legislation for its own protection, basically. That you can't be part of an advocacy group, you can't protest or show any form of dissent, or industrial action like a walkout or a boycott. So section 3 is very weird in that it's turned anybody that wants to stand up and have a voice against the state into a terrorist that would be someone that causes a terrorist act of harm to property, life or limb. Made it very difficult for anybody to say anything against the state, and then as you'll see, they've already attempted to use their psychiatry or forensic quackery to back up their claim here. And we're only starting to get into what we're about to look at. I've already gone through this multiple times. But as we start to look at the legislation that precedes it, we start to see that there is a very twisted way the state views rightful action from wrong and terrorism to the extreme of stopping protesting activity against what could be considered industrial negligence, oil spill, nuclear power plant having a failure. That these are industrial accidents that could have forms of negligence that would require some form of dissent, and that is now turned into a terrorist act. So it's a very fine line the state's decided to play here. This, I guess, defines how a person disseminates information that would incite people into the aforementioned terrorist acts, which on the front side are pretty reasonable, and that's what you would expect in the protection of life, limb and the state. But when it turns itself into protest, dissent or industrial action, you start to see state protecting itself. So what is disseminating this kind of material? Would voting material be considered collecting or making documents likely to facilitate terrorist acts? 1. A person commits an offence if A. The person collects or makes a document, and B. The document is connected with preparation for the engagement of a person in or assistance in a terrorist act, and C. The person mentioned in paragraph A knows of the connection described in paragraph B. Penalty for imprisonment 15 years. Publishing information that is inciting any sort of violence or terrorism or dissent, in the sense of trying to stop a government from doing its duties to the public trust that it's obligated to manage, would be considered a criminal offence. But when it comes to protest and advocacy, so that would make Amnesty International a terrorist organisation for advocating action against what could be construed as humanitarian offences that Australia commits. So where does the line get drawn here? Are they publishing or collecting and making documents likely to facilitate anything? It's a fine line on defining who is at threat. Is the state at threat? Because the plaintiff is State of New South Wales here against a defendant. So obviously the state feels threatened. By what? That's the question. By what?